Hello and welcome to Trusts and Estates Virtual Forums, Keeping Up with New Developments, produced by Trusts and Estates and WealthManagement.com. Today's session is entitled The Impact of Divorce on Estate Planning and Wealth Management, and is sponsored by Fiduciary Trust. I'm Susan Lipp, Editor-in-Chief of Trusts and Estates, and I'll be your moderator today. In a moment, I'll be turning things over to our speakers, but first, let me explain how you can get the most out of this event. To improve your viewing and listening experience, you can move your webcast windows around by dragging on the title bar or resize them by clicking on their lower right corner. At the bottom of your screen, you'll find multiple application widgets. By clicking on these buttons, you can open and close widgets on your screen. A copy of the slides is available for download in the resource list widget. Also, located in that resource list widget are instructions for continuing education credits. Please note this webcast has been accepted for 1 CE credit hour towards the AEP designation program. The live broadcast of this event has been approved for 1 CFP Board CE credit hour. Investments and Wealth Institute has accepted this program for 1 hour of CE credit towards the CIMA, CPWA, CIMC, and RMA certifications. Instructions for credit submittal are available in the resource list widget. For those attorneys in the audience getting CLE credit, please listen for a code word that will be stated at some point during the webinar. To get your credit, you'll need to put that code word into the survey that appears at the end of the webinar. You must also include your bar number and state of practice to receive the CLE credit. You can open the survey at any time by clicking on the survey widget on your screen. And again, please note that the CLE credit pertains only to attorneys. Please also be aware that today's session is being recorded and will be available for on-demand viewing following the event. So now let me introduce today's speakers. First, we have Nicole Kobus, who's a partner at Lindabury, McCormick, Estabrook Cooper. And joining Nicole is Elizabeth Candido Petit, also a partner at Lindabury, McCormick, Estabrook Cooper, and Jody King, who is Director of Wealth Planning at Fiduciary Trust. You can find more information about today's presenters by clicking on the speaker bio widget at the bottom of your screen. So with that, let's get started. And Jody, I will turn the floor over to you.
Thank you, Susan, and good morning, everyone. It's nice to have you joining us. On behalf of Fiduciary Trust, we are honored to be sponsoring today's seminar. And in case you're not familiar with Fiduciary Trust, we are a New England-based, privately held, comprehensive investment and wealth management provider with a 135-year history and $23 billion under supervision. Our 98% client retention ratio results in relationships that are measured in decades and generations. We provide a broad range of wealth services, including wealth planning, donor-advised funds, investment management, and trustee services, including access to the very attractive New Hampshire trust law. If you would like to learn more, please visit us at fidtrustco.com. That's FIDTRUSTCO.com. So to move into today's webinar, I wanted to talk about how we are going to do this today. So we're going to look at basically 3 different areas, as well as save time for some Q&A at the end. We're going to start with family asset considerations, then talk about what happens in the event of a divorce, what you can do post-divorce, and then, as I said, the Q&A. So moving first to family asset considerations, I wanted to start to talk about relationships and finances. You know, finances can clearly be a point of tension in marriages in particular, but actually they can be a point of tension in any relationship, family relationship or otherwise. Finance and discussions around money can be impacted by someone's relationship with money. Believe it or not, we all have a relationship with money, just like we have a relationship with others. Often the relationship with money will be rooted in childhood, and that you carry that into your marriage, and your relationship may be very different than your spouse's relationship, and that can be a source of conflict. For parents, one of the best ways to help children have a healthy relationship with money is around family finances and making it a topic, making it not a taboo topic, but making it something that you can talk about with each other so that money becomes a source of discussion as opposed to a source of tension. The goal is for children and all adults not to fear money, but to be empowered, to empower your family members around finances. And so with divorce as our main topic today, one thing I always want to think about is asset protection. And the concept of family asset protection I always encourage to be introduced early in the family. And it can be introduced in age-appropriate ways, but at some point, hopefully before Mr. Wrong or Mr. Right is introduced into the family, if prenups are a concept that your family wants to talk about, that should be brought up long before that person is brought in. I always encourage families and individuals, if it's not in the family context, but once someone is an adult, they need to gather their own financial understanding. Knowing what you have and what you need is very important to everyone, regardless of your age or wealth level. Knowledge, as we often hear, is power, and this clearly is appropriate in the wealth planning and financial understanding arena. So keeping in mind that marriage and divorce are always emotionally charged, discussing, as I mentioned before, the reasons for a prenup may be easier when there's been a kind of foundation laid that family financial discussions are not taboo. And then that can be introduced early when it's not an emotionally charged topic with regard to who may also be entering the relationship of the family. So I'm going to go ahead and turn it over to Nicole.
Great. Thanks, Jody. Hi, everyone. Thanks so much for being here. So I focus my law practice on family law. So I do basically divorce day in and day out. I do a lot of prenuptial agreements and also non-dissolution matters as well as mediations. And like Jody said, it is a very emotionally charged area of the law. So prenuptial agreements are a way to try to remove some of the emotion from that and make decisions about difficult things when emotions are good rather than when emotions are bad. So I'm sure everyone has a pretty much general understanding of what a prenuptial agreement is based on, maybe your own personal knowledge, your knowledge of your clients, or also just in, general social news, because obviously prenuptial agreements tend to be a bit of a hot topic. So what is a prenuptial agreement? At the heart of it, it is an agreement between two people that are contemplating marriage. It is entered into before a wedding, not after, and the consideration in the contract, so what the give and take is in the contract, is based on is the marriage itself. So if for some reason an engagement breaks up or the marriage doesn't happen, the agreement is no longer valid. Prenuptial agreements are not just for the rich and famous, which I feel like is a very big misconception. It can be for anyone. So who needs one? If you feel like you need one, you should at least consult with an attorney as to why you might need one. Prenuptial agreements are much more complicated than I think most people think they are. They take into consideration a lot of different items. But when is a prenuptial agreement in particular very important? Second marriages, when there's already financial obligations to a first family, it's definitely a very popular time to get a prenuptial agreement. When you have children in prior relationships and then you're entering into a new family, whether that means you're entering it into when you're young or when you're later in life, it's very important to make sure that you feel that your children from a previous relationship are adequately protected with whatever finances you have. When you have a very different earning capability to a spouse, if you know off the bat that you are going to out-earn your spouse tenfold, it might be something that you want to consider because you know that if you are out-earning a spouse and you get divorced, you might end up having a large alimony obligation. So these are kind of conversations that you could have prior to emotions getting to the best of you. If you're going to have anticipated inheritance or if you have a family business, you want to make sure that those assets are going to be protected. And every state, there are certain provisions that are put in place that protect those assets, but a prenuptial agreement just makes it a little more secure and makes you not have to worry about segregating assets as distinctly as if you didn't have a prenuptial agreement. So all things that should be considered before marriage. So when does a prenuptial agreement have to get signed? It has to get signed before the wedding happens. prenuptial agreements do not take only a few weeks to draft. They take months to draft. So I always advise clients when they come to talk to me, it is never too early to start doing a prenup. It only can be too late to start doing a prenup. As you get closer to the date of your marriage, prenups become more suspect. Was someone forced to do it? Was there an ultimatum? Was it do this or we're not getting married? Did you have enough time to review it? Do you feel that you were able to review your future spouse's assets to a satisfactory level? Were you able to get appraisals done of businesses? All these questions come into play and become more challenging to deal with when a prenuptial agreement is signed closer to marriage. Why are prenuptial agreements important? So I practice in New Jersey, and in New Jersey, a prenuptial agreement is the only way that you can disinherit your spouse by having them waive the elective share. That doesn't mean that waiver has to be forever. It could mean that you both execute wills after your marriage that don't waive the elective share, and then those wills will become valid. But if you potentially want to explore a different form of asset planning that does not involve your spouse for one reason or another, a prenuptial agreement is really your only way in order to do that. So what goes into a prenuptial agreement? I've talked a lot about what it is, but what are we actually talking about? Alimony and spousal support. Always a big issue that is dealt with in a prenuptial agreement, whether it means that parties are waiving alimony or spousal support, whether it means that you're setting conditions on alimony or spousal support. For example, it's very popular to say we have to be married for X number of years before either party is entitled to alimony, or potentially we must have children before anyone is entitled to alimony. Things like that are always dealt with in prenuptial agreements. Equitable distribution. So equitable distribution is a fancy way of obviously saying you're dividing your assets. If there are certain things that one party wants to keep exempt from equitable distribution, this would be a perfect way to be able to deal with it now. So whether that means you came into the marriage with a bank account, you would deal with it then. Whether it means that there's potentially family properties that you want to ensure stay within your family as opposed to being divided, another example of something that would be dealt with in an agreement. Inherited assets. So a lot of states do already provide that inherited assets or to be inherited assets will be exempt from equitable distribution, meaning that they will stay with the party that actually inherited them. However, what a prenuptial agreement does, it makes it a little more ironclad. It prevents from what happens when assets get commingled, or if all of a sudden you need to pull from grandma's account that you got to fix the roof, but you want that money back. Unless you have those kind of provisions in a prenuptial agreement, that money is going to unfortunately be considered part of the marital estate. Other things, treatment of your spouse's estate's assets. These are all conversations that you can have when you're doing a prenuptial agreement when times are good rather when times are bad. Very important to note that child-related issues are not dealt with in prenuptial agreements. If they are dealt with in prenuptial agreements, courts will throw them out if at the end of the day people are looking to enforce them. The biggest things that a prenuptial agreement must have, first and foremost, full disclosure of assets. At the end of every prenup that I do, are extensive charts outlining every single bank account, every single credit card, every single property, every single trust, asset, etc., with a value. That is important because in order for a prenuptial agreement to be valid is you need to have a full disclosure of every single asset that currently people have when they enter it. So that way you know whether or not the agreement is fair, whether it is conscionable or whether it's unconscionable. Both parties must have the opportunity to review the agreement with independent counsel. I personally will not do a prenuptial agreement unless there are two attorneys. I feel that it ends up being a bit of a slippery slope that someone can try to then undo a prenuptial agreement saying they didn't understand this, they didn't understand that. So it's very, very important that everyone has the opportunity to have someone help them understand each and every provision of what they are giving up and what they're getting in return. And of course, as I said before, it has to be something that is voluntarily entered into. Typically, both parties don't necessarily want a prenuptial agreement. There's usually one party that is the driving force behind it. So it's very important to make sure that everyone knows what their rights are and everyone knows that there are options other than entering into this agreement. I'll turn it over to Elizabeth to talk about trust, which is another way that you can try to protect some assets. Right, Elizabeth?
Yes, thanks, Nicole. My name is Elizabeth Petit. I'm also a partner at Lindabury, and I focus on estate planning and estate administration. So trusts are one way that the family can protect their own assets and Generally speaking, that's maybe a better protection than prenups if you have a lot of family assets, because then it's the parents who are really deciding what happens to that money, where it goes, and how it's taken care of. So a trust is usually created by a parent or maybe a grandparent or other family member. The trust is irrevocable, meaning that it can't be changed, or maybe it can under certain state statutes, but generally speaking, it cannot be changed. Provided that the trust is sort of drafted properly, it provides a lot of protection for the assets that are held in that trust. So in terms of when you're getting a divorce, the divorcing spouse is essentially a creditor, or sometimes we refer to them as predators, that are being sort of protected, or you're protecting your assets against them. So if the trust provides a spendthrift provision, then that allows creditors to not gain access to the trust. Essentially, once trust assets are distributed out of the trust, it's fair game. So the idea is you want to make distributions from the trust as limited as possible, or fully discretionary by the trustee. For example, if the trust says all income is distributed quarterly, then as soon as that income is distributed, or even if it is not distributed, if it should be distributed, then that's accessible to a creditor, including a divorcing spouse. The other thing is that the trustee should have the full discretion to make the distributions, whether it's the income, whether it's the principal, and that way the creditor cannot demand a distribution in the same way that the beneficiary would not be allowed to demand a distribution from the trust. So I mentioned that trust should be spendthrift trust. This is really not that difficult. Most states provide either automatically or with a pretty simple provision included in the trust that a trust is a spendthrift trust. So I included here the New York on the top and then the New Jersey on the bottom statute. So New York basically says all trusts are spendthrift trusts unless provided otherwise. So that's really easy. New Jersey is basically, so long as you say this is a spendthrift trust, you have those powers. So it's not hard to create a spendthrift trust. And frankly, every trust that I prepare, whether there's a specter of divorce or whatever the case may be, is a spendthrift trust. Now, what about the trustee selection? So the beneficiary probably should not be a trustee to really get the most favorable asset protection of the trust, because then the beneficiary has no control over who it is who's making the distribution. Some states allow the beneficiary to be a trustee, either the sole trustee or a co-trustee, and still have it be a spendthrift trust. That's New Jersey's rule. Personally, I would prefer to not have the beneficiary be in the trustee seat, to just make it clear that they are not the person who's in charge of any distributions from the trust. So some pitfalls with trust, as I mentioned before, once the assets are distributed, it's fair game. The divorcing spouse, a creditor, if you get into a car accident and are sued, whatever, they can attach to those assets. They've lost any protection that the trust would have otherwise provided. Public policy in many states requires alimony and child support to be paid from the trust, regardless of what it says. So it's not a fail-type protection against keeping these assets from, your family or your ex-family. Some states have sort of been attacking trusts, so to speak. There's a pretty well-known case from Massachusetts, Levitan v. Rosen, from a few years ago, where the court said, we don't really care that there's this trust. The family was using these funds sort of to, support their lifestyle, and we're going to include them when we distribute the assets among the divorcing spouses. So this is important because even though not all states have this as their trust law, your client might have a child who lives in Massachusetts. They could move to that state. Another state could adopt this rule. So it's something to keep in mind that, trusts provide a lot of really good benefits, but they're not 100% fail safe. There are things to keep in mind that it may be possible for a spouse or a creditor or anyone to get the trust assets, even if that was not your intention.
Before we go to the next slide, I just wanted to say the code word for those attorneys in the audience who would like to get CLE credit. The code word is prenup. That's prenup. So please put that into the survey that appears at the end of the webinar, and you will be able to get your CLE credit. And I'll turn it back to Nicole.
Thanks, Susan. So while there is plenty of ways to plan for a divorce, what happens ultimately if a divorce happens? So you can put any trust in place, you can have a prenuptial agreement, but ultimately if someone wants out of the marriage, then there's going to have to be financial changes that happen and planning and other divisions that occur as a result of a divorce. So at the onset of a divorce, it's a very simple concept. A divorce is going to mean that parties have to tighten their budgets. Whether you have $500 or $500,000 or $500 million, it's going to mean that there is one pot of money that has to be divided in some fashion to support two households, as opposed to that one pot of money supporting one household. It is a very hard concept often because for the average American, even for the upper middle class American, that is going to mean a change of lifestyle, ultimately, changes in where you might live, changes in how you're going to spend your money, potential changes of careers in order to earn more money to support your now respective household. And it's a very hard reality for many people to understand, especially if you are the one that does not necessarily want the divorce, but are being taken along for the ride at this point. So when you are faced with a divorce, whether it means you're the one that wants the divorce or whether it means the one that you're being faced with the spouse saying, I want out of this marriage, what should you do first? I always recommend that you consult with an attorney as soon as possible. And it doesn't necessarily mean that you have to sign on with an attorney right then and there. It doesn't necessarily mean that you have to choose that attorney to ultimately represent you. An attorney will allow a divorcing spouse to become an informed consumer. You will understand what your rights are. You will understand what the downsides of the arguments that you're about to make. You're going to understand what your weaknesses are. And ultimately, knowledge is going to be power. You're going to feel more empowered to enter into this life change. And you're also going to understand what is going to happen along the way. Before you meet with an attorney, most attorneys are going to say, we need a better financial picture of where you and your spouse are in order to be able to advise you. That is sometimes very difficult for people, as there are some marriages where one person really has been kind of kept in the financial closet and doesn't have even an idea of what the mortgage payment is, let alone anything else that is going on in the marriage. It also could be very easy for some who are in charge of the finances and can probably have everything saved on their desktop and neatly, filed folders. So the basic idea of financial information that you're going to want to bring to an attorney: tax returns, paychecks, monthly bills. Try to get a better picture of what the month-to-month finances are. Are you living in debt? Are you living on credit cards? Do you have two mortgages on the house and there's no equity in the marital home at this point from overspending? Things like that are going to be really important and going to help the conversation with your attorney in order to frame what the next steps are and what ultimately could happen at the end of this divorce. So in most states, at the onset of a divorce, towards the beginning of the process, is you have to file a financial document giving full disclosure of where assets are. Similar to a prenup with financial disclosure, this is part of the divorce process. In New Jersey, this form is about an 11-page form. It will ask you for your paychecks. It'll ask you for your tax returns, both this year and last year. It's going to ask you a series of questions about whether you've received a bonus, whether you're anticipating getting a bonus, whether you've received stocks, whether you have received unemployment benefits, things like that. It's also going to require you to complete a budget, which frankly, I was speaking to a client yesterday and I said that even though the exercise is tedious and daunting, it is an exercise that everyone should go through, whether they're divorcing or not, to really see where your money is going on a monthly basis. It's not necessarily the one-time $500 charge that gets people. It's the 4 times a month $100 charge that ultimately adds up and that people just don't realize that they're spending. So it's a really good exercise to do this budget, and something that I encourage all of my clients to do as quickly as possible to get a better handle on their finances. You'll have to disclose all of your assets. That's going to mean your real estate. It's going to mean your investment accounts. It's going to mean retirement accounts. It's going to mean whole life insurance policies that have a cash value. It's going to mean businesses, cars, expensive jewelry, paintings, collectibles, anything under the sun that has any kind of value that was accumulated during the marriage, but also things that you came to the marriage with. You'll be able to mark them as exempt, but the courts require full disclosure of everything that you have. It's also going to have you list your liabilities. Liabilities are going to mean your mortgages. They're going to mean your credit card debts. It's going to mean the loan that you took from your parents, to add an addition onto your house. It's going to mean your student loans. It's going to mean the student loans that you took out for your children, and really come down to a bottom line of whether you are living in the red or living in the black at the end of the day. And then from there, it paints a picture of what ultimately is going to be subject to equitable distribution during the divorce. So divorces, unfortunately, they don't happen overnight. And especially with COVID, the court system is moving even slower than it was before. Obviously, there are other alternative dispute resolution avenues, such as mediation, which provide an even better way to resolve your dispute. But unfortunately, they do not happen overnight. And unfortunately, things can change during a divorce. So what happens if your spouse dies in the middle of a divorce? Unfortunately, it has happened before, sadly. What the misconception is that you are married until you are divorced. There is no gray area, at least in New Jersey, as to whether you're going to be treated as married or divorced. So when you file a complaint for divorce, while that triggers certain things in terms of the divorce process and in terms of how assets will be divided, it still means you are married. So for example, for purposes of like tax filings in the IRS, you will still have to file a married tax return. It doesn't mean that you have to file a joint tax return. It means that you'll either file married filing jointly or married filing separately. You cannot file a single tax return, for example, until after a judgment of divorce is entered in a case. So if for some reason your spouse would pass away in the middle of a divorce proceeding, the matter then gets switched over to the probate chancery realm, where the court then is going to be charged with fashioning some kind of remedy similar to equitable distribution as to what would be fair. They will essentially try to put themselves in the seat as if you were getting divorced, how both spouses would have ended up at the end of the day, and try to figure out what assets should go where and how best to divide them, even though now one spouse has passed away. Elizabeth, you want to take it from here?
Sorry, I forgot to unmute myself. As Nicole mentioned, you are married until you are actually divorced, and public policy does not allow you to disinherit one spouse, or it's not easy to do. Nicole had mentioned you can do it through a prenup, but if you don't have that, then your spouse is entitled to certain rights. Community property states, there's 9 total, I listed them there. In those states, the surviving spouse automatically receives half of the community property, and anything that's acquired during the marriage is considered community property. In the common law states, all the rest, the spouse has something called the right of election. They can elect against the decedent's will and receive an elective share, and that is true regardless of what the terms of the will say. So that's something important to keep in mind, that, even if your will says, I give everything to my 2 children equally, if the divorce is not final yet, your soon-to-be former spouse still has a right in your estate. The elective share is decided based on state law, and of course, all states are a little bit different. The general answer is that it's a third of the estate. New York is the greater of $50,000 or a third of the estate. New Jersey's little variation is that it's 1/3 of the augmented estate. And what that means is that it takes into account certain non-probate assets like a pension or a retirement account or a bank account with a designated beneficiary, things that don't typically go through the probate process. And it also looks at what the surviving spouse's own assets are. So if the decedent is the less moneyed spouse and the survivor has, millions of dollars, then they might not actually get anything through the right of election, but it's still they still have the right to go through that exercise and see what all the assets are. So the right of election, it's not automatic like in community property states, it has to be elected. It's not something that the court can just say, oh, this will doesn't provide for a spouse. No, the surviving spouse has to actually file a proceeding, or whatever that court is going to call it, petition, complaint, motion, to elect. And there's a certain amount of time to do that. 6 months is the New Jersey rule, I believe. So there's you have to act relatively quickly. It can be waived through a prenup agreement, but again, that, as Nicole was saying before, sometimes people try to attack prenups, and this is one of the areas where I see it often. Well, yeah, there's a prenup, but mom didn't know what she was signing, or I didn't know what I was signing, so it's not valid, and therefore, the waiver of the right of election isn't valid, so I should still get the portion of the decedent's estate. So a lot of times people say, well, I'm getting divorced. I don't want to leave my spouse anything. Does it make sense to have a will right now? The answer is always yes. You should always have a will, even if you do have to provide for your spouse through the elective share. And what the will often would say is, I leave my spouse, 1/3 of my estate, or you could phrase it as the right of election, however you want to refer to the proper statute in your state. And then the rest of the estate can go to whoever else you want. Children, charities, maybe the new person who's going to be your spouse once this divorce is finally done, whoever, it doesn't matter. But the spouse that you're currently married to must have that right. And the problem is, if you do not have a will, your state's intestacy rules would apply if you were to die before the divorce is final. So the intestacy statutes govern two main things. Number one is who gets your property. And under intestacy, the spouse is going to be entitled to some or all of the property, depending on whether you had children together, whether you have children from a prior marriage, or whether it's just you and your spouse. So whereas if you had a will, you could provide that your spouse gets 1/3 of the estate or thereabouts. If you don't have a will, spouse is getting everything, and there's nothing you can do about that. The other thing that the will can do is it can choose who's going to serve as your executor. That could be anyone. There's absolutely no requirement that a married couple name each other as executor. And often, a lot of times, I'll see when I'm dealing with an older couple, maybe one of them is not in good health. They will not name their spouse. They will name an adult child. So that's an example where, there's no divorce in sight, but the family decides that it doesn't make sense for the survivor to serve as executor anyway. So point is, you can name whoever you want. On the flip side, if you do not have a will, then your spouse is the first person who is entitled to serve as the administrator of your estate. They might say, no, thanks, I don't want to do it, but that would be on them to say. So that's the other benefit of executing a will during a divorce. Of course, people say, yeah, but I'm spending so much money on my divorce attorney, I don't want to shell out even a penny to another lawyer, and understandable, but sometimes the bigger picture is more important to really consider. So as I mentioned, the fiduciary, in my opinion, is the big reason, and if you had a will, you could change your will to name someone else, even if you leave the provision that your spouse receives some of your property. So this is why doing some estate planning during the divorce is always a good idea. I always think about it this way. If you passed away before the divorce was final and your spouse, who is soon to be your ex-spouse, were to serve as executor, is that the person that you would want serving as executor? Keep in mind the executor has sort of two roles. One is collecting the assets, and that's, the less emotional maybe part of this, collecting the bank accounts, deciding what bills get paid, who gets what, etc. But then there's the more emotional side, and this is where families fight, even when there was not a divorce going on, of dividing all of the tangible property. Do you want your soon-to-be ex-spouse going through your closet and deciding what happens to all of your clothes or your artwork or whatever the case may be. Usually that stuff is very personal, and that's what you want maybe your adult child to do instead of this guy that you hate and you hope you never have to see again. So that's one real important thing to keep in mind, that it is possible, and it probably should happen, that you make some changes to your estate planning in the middle of the divorce. Nicole?
So changing beneficiaries of non-probate assets. So let's just take a step back and discuss what a non-probate asset is. So non-probate assets are items that don't have to go through the probate process, that pass by way of a beneficiary designation. So for example, your pension accounts, your retirement accounts, life insurance. Those are the common ones that we see in both estate planning and also in divorces that ultimately have to be dealt with. So in theory, when you enter into, let's say, a job and you fill out your 401k form, it always asks you for who your first beneficiary is. Typically, if you're not going to choose your spouse, you need to have your spouse's consent to choose someone else. So let's start off from the fact that your spouse is typically going to be on all of your retirement accounts. So then what happens if then there comes a time where there is a divorce? Can you remove your spouse as beneficiary on these assets? The short answer, but pretty much the hard answer, is no, don't do it. Because it's just going to create more problems. It's going to create a situation where your spouse can then ask to be put back on, which is just going to cost more money in the end of the day. Or it can unfortunately result in a situation where money is paid out improperly and now you're in a litigation with whoever the money was paid out to. So you can't do it. Some states even take it a step further. So in New Jersey, when you file your complaint for divorce, you also have to file a document that's a certification of insurance coverage. That insurance coverage statement provides every single insurance policy that currently exists. So that's going to be your health insurance. It's going to be your homeowners, your auto, your disability, and your life insurance. Life insurance is a big one for the purposes of what we're talking about. It's going to provide for what beneficiaries are listed, what the death benefit is, what the titling is, the premium, whether the peer premium is current, everything under the sun. It also is certifying to that no changes have been made within 90 days of filing that form. So it prevents divorce planning. It prevents someone from saying, things are not going well. I have, a new boyfriend. I want him to get my life insurance. I'm going to make the switch and then I'm going to file for divorce. There's a look back period of 90 days. So you just want to be careful, because ultimately, if you've made the change, it's just going to cost more money undoing the change. You're not going to be able to really get around it, absent a consent order or some kind of agreement otherwise. So it's really important to know that there's some assets that are going to be tricky until a divorce is actually finalized, because you can't make any changes to them during the divorce process. Jody?
Yeah, thank you, Nicole. So I'm going to talk about asset division here for a little bit, but in response to one of the questions in the chat, I also want to point out that the rules around asset division are very much state law specific. And, as we pointed out earlier, that, Massachusetts has some case law that indicates that things may not go exactly like it might go in other states. In Massachusetts, I'm actually in Massachusetts. With a long-term marriage, the saying here is anything and everything, however and whenever acquired, is on the table. So that means inheritance are on the table, assets you come into the marriage with can be on the table, gifts, future inheritance can be considered. So there's a lot to it that can vary by state. So in response to the one question in the chat, it really is very state dependent, and you need to know your state law. So one of the things with asset division, it's really important to try to remove emotions from the asset division planning, because if you can agree, if the married couple can agree on how asset division is going to go and be fair to each of them, it's probably best, right? But even assets with the same fair market value may not have the same actual value in the post-divorce world. So, things to think about: is the asset income producing? Is it the asset liquid or illiquid? Is it a retirement asset that may not be accessible for a period of time, or may have some tax consequences when it's accessible, right? Are there embedded taxable gains in the asset, or maybe some other consequences to accessing the assets? Are there expenses associated with maintaining the asset? Or is it just an investment asset that will sit there and be invested? And is there any debt associated with the asset? That becomes very important as well. So I'm going to spend a few moments here, and we have a couple, Quinn and Morgan. They're both about age 50, and their net worth is about $1.3 million, and they have a variety of assets. So basically, we have cash, we have an investment account or two investment accounts, each about $100,000. A traditional IRA 401k of about $300,000, a Roth IRA 401k of about $300,000, the marital residence about $800,000, and about $300,000 in debt on it. So if we were in a state that ended up with this being equally divided, and I know we talked about equitable division, which is a little bit different sometimes than equal division, but for this discussion, I'm going to go with equal division. They'd each receive about $660,000 of value. So a couple different ways that could be done, and neither one of these are what you'd want to do exactly, but just to illustrate the importance. And, I saw also a question in the chat about using a CDFA, and a CDFA or a financial planner is really good to have if you don't have a handle on the asset values and what their after-tax impact may look like and their accessibility. Having someone, again, knowledge is power. Nicole has said that, I've said that, and having someone consulting with you and the attorney and being part of the team to make sure that you have the knowledge, you understand what your situation looks like, makes a lot of sense. So in this scenario, you see here where each spouse is going to have the $660,000 at the end of the day, but Quinn has chosen the marital residence. That makes up, $800,000 minus the $300,000 mortgage. That makes up $500,000 of Quinn's $660,000. So on top of that, they have a traditional IRA of half of that, and some cash. And so they had to give up some things in order to maintain the marital residence. And with that means we have an asset that is going to require a cash outlay over time to maintain that, as well as to pay the mortgage. And there really isn't much that they have available to pay that, versus Morgan is walking away with the investment assets, the traditional IRA, the more tax-preferred Roth IRA. So a much more liquid situation, although the asset values look the same. So remember, the key takeaway here on this, for this illustration, is sufficient liquidity and access to assets is really important. When someone is thinking about being divorced, the motion of keeping the marital residence and wanting to keep the kids in the marital residence, sleeping in their own bedroom, all of that is very important. However, it may not be the best financial decision that can be made by the couple. It's often not a good choice to maintain the marital residence. As Nicole said, there's a very good chance that the finances of the family, there's going to be required belt tightening and some choices being made along the way in order to maintain whatever lifestyle might be available to them. So recognizing real estate can be a very positive way to build wealth, but if it's too higher percentage of assets, it really will limit future flexibility. And this may not be a good choice for Quinn to walk away with that asset makeup. Looking then back to Quinn and Morgan again, but focusing that not all assets are created equal. Here, they walk away with, they decide to sell the marital residence, so they each get the net $250,000. That's $800,000 minus the $300,000 mortgage for $500,000 split between them, a net $250,000. They split the cash. Each one takes an investment account, and just note over here that one at a cost basis of $10,000, one at a cost basis of $90,000, and then Quinn takes the traditional IRA and Morgan takes the Roth IRA. So they both have their $660,000, right? But when we look at the after-tax value, which is the columns on the far right, cash is cash. That is full fair market value or full after-tax value. But when the investment accounts, when you look at the cost basis of $10,000 versus $90,000, with some basic assumptions around capital gains rates, if Quinn needed to liquidate that investment account, that $100,000 account may only be worth $82,000 after tax, versus the higher cost basis in the account that Morgan has on their side has a $98,000 value. So that's a big difference. And the traditional IRA, when you take assets out of that, would be fully taxable, not accessible until you're 59 and a half in most cases, but fully taxable. So after tax, again, with an assumed tax rate, we'd have about a $210,000 after-tax value, versus the Roth IRA being a little more accessible, actually, potentially before 59 and a half, but also not having any income tax consequences for taking assets out of that when it is accessible, would end up with a full $300,000 there, because we're not paying the ordinary income tax you do on the traditional. So where they both walked away with $660,000 in value, the after-tax value means Quinn really only has $552,000 and Morgan has $658,000. So here, although it looks a little more equal, it's not necessarily, because there's over $100,000 tax swing, if you will, on those accounts. So the key takeaways here that I want to talk about is that the sale of the residence really does provide liquidity for other options. And that's one of the things liquidity really does create options for people. You need to always be aware of the tax basis of all assets, as well as the accessibility on those assets and whether you can access them when you want. I want to just kind of circle back and remind us of a few things when we're dividing assets. Emotional connections to assets can impact choices, and it really is important, and we've said this before, that the emotions associated with real estate or tangible personal property, jewelry, or some art collections or whatever, you need to kind of have those in mind as you're making decisions, and really make sure that you're making the right choices, or your client's making the right choices. Liquidity is necessary. Everyone needs an income stream to live, which can come from employment assets, employment income, or if it's coming from investment assets, you need to pay attention to that and make sure that that's available. Selling a personal residence may be the best while you're still married, filing jointly, so you can take advantage of the full $500,000 exclusion. If you do have a gain on that residence, that's something to think about on an after-tax basis. As I illustrated before, the tax or cost basis should be taken into account when you're dividing assets. Distributions from IRAs and Roth IRAs should be thought about because they are different as far as what the after-tax benefit of those might be. And I want to also talk a little bit about treatment of irrevocable trust will vary by jurisdiction, and the particular facts and circumstances of the situation can impact how those are divided, if they're divided, or if maybe they're just considered to be an asset of one spouse that then impacts the division of the other assets, which is often what we see again here in Massachusetts, which each state varies greatly, and so it's important to understand what state your couple is in as they're doing the divorce. So I'm going to turn this back over to Nicole, and Nicole, I think you're going to start with post-divorce.
Yep, thanks, Jody. So what happens after a divorce? So you go through the emotional, turmoil of getting a divorce. You get through the divorce, you tighten your budget, you might sell a house. You have to now figure out what the new transition of the next normal part of your life is going to be. So one of the main things that is a misconception is that your judgment of divorce and your settlement agreement, despite what it might say, does not actually change any beneficiaries that you may have. You must physically go to each financial institution or each life insurance company and file one of those change of beneficiary forms in order for your beneficiary change to be valid. I can't stress this enough how important this is. Financial institutions do not care what your divorce documents say. They do not care how much you hate your former spouse. They see your former spouse listed as the beneficiary, you pass away, the money is going to them. They don't get involved with a dispute as to whether or not this is right, wrong, or indifferent. So I cannot stress enough to my clients that as soon as the divorce is finalized, I always provide them with a list of here are all the assets that have beneficiaries. These are the ones that you need to contact immediately and make whatever changes you want. The last thing you want is for your children or your new spouse or your parents or your siblings to be dealing with litigation because you did not do what you were supposed to do and change your beneficiary. So it's something that is so crucial, yet often something that is overlooked because by the time a divorce is done, you're almost emotionally drained. You're trying to figure out the next chapter and how things are going to operate. But there's still very important considerations that have to be dealt with after a divorce is over.
Yeah, as Nicole said, the changing the beneficiaries of those accounts is really important for all my estate planning clients. I always have them take a look at who the beneficiaries are, even if they're not, newly divorced or whatever. I just had a new matter come in as an aside where a guy passed away and he had named his sister on beneficiary designations from like 35 years ago before he had kids, and now he passed away and the sister gets everything from these accounts, which have they're not insignificant, and the kids are sort of like, what about me? So now we have to figure out how this family is going to handle this. So always very, very important. Check the beneficiary designations, check them a lot, check them often. But the good news is, once you get divorced, changing your estate planning documents is a lot easier to eliminate your ex-spouse now. As a beneficiary, you no longer have that right of election hanging over you. You can, feel free to remove them as fiduciary if you haven't already done so. So after someone gets divorced, they should always review their estate planning documents and make changes. Now, some states do provide that the divorce automatically revokes certain things. For example, a disposition under a will. If you forget to change your will, or you're just like, I can't spend another penny on a lawyer, I'm not doing it right now, and then it never happens. If your will leaves everything to your now former spouse, he is or she is considered to have predeceased you, and that would not be valid. Obviously, the will only governs probate assets, which is why the beneficiary designations are so important. So again, the divorce will void a fiduciary designation, such as an executor or a trustee, or a power of attorney for a lifetime estate planning document, as well as right of survivorship of jointly owned assets. So if you had a bank account that had both your names on it, and for whatever reason that was not changed during the divorce, you could prove that that was really your account and your spouse was just named there for convenience or whatever purposes, the divorce decree would govern that, and your former spouse would not receive that account as a result of your death. One thing to keep in mind is that this default rule that sort of eliminates the spouse does not always apply past the spouse. So for example, if you named your spouse as the first executor and then maybe your father-in-law as the backup executor, which I see all the time, especially for younger couples doing estate planning maybe for the first time, when you're obviously not going to name your kids because either you don't have kids or they're minors, and you have a good relationship with your in-laws and maybe they live close by. Sure, I'll name my father-in-law as the backup executor. So not all states will void that father-in-law from your documents. So let's say you don't change your will and your spouse is still named as executor. Well, he's out, but his dad is in. So his dad could potentially still serve as your executor. There was a New York case from 6 or 7 years ago where this exact same thing happened. So again, think back, who is the person you want going through your closet and looking at your clothes and looking at all the little random memorabilia that you have? Probably not your former spouse's father. So that's a really good reason to take a look and make sure that these documents really do say what you want them to say at every stage of your life. Jody?
Yeah, thanks, Elizabeth. So a wealth plan is something everyone needs. Whether you're single, married, divorced, divorcing, you should always have a plan. So just to focus on the right-hand side of this slide for a moment, as Liz was talking about updating your estate plan, I just want to remind everyone that the core documents are the will we've talked about. If you have a revocable trust, you'll want to revisit that. One thing that I always encourage people to think about is your healthcare proxy or your living will and your healthcare directives, like who's named there. Because again, just like you may not want someone going through your personal effects, you may not want them making healthcare decisions for you either anymore. And make sure your durable power of attorney has the right parties named in it as well. And, as everyone has said, revisit those beneficiary designations often. Looking at the financial planning side, I always encourage people to remember to be realistic. What are my assets? Hopefully they've gotten in touch with what their assets are during the divorce if they didn't know before, but what are my assets? How should my assets be invested? Do I need them producing income? Are these assets that I'm really going to try not to touch until later in my life? What is the purpose of these assets? Make sure they're invested appropriately given not only what your time frame is and what your needs are, but also what the market conditions are, right? What are your income sources? Is it alimony? Is it employment income? Is it investment assets? Is it something else? Do you need to change jobs to earn more money or get an education, more of an education so you can earn a different salary? Understand your expenses, your liabilities. It's really important to guard your credit in a newly divorced situation. You want to make sure that, if you need access to credit, that you've taken care of your credit along the way. That applies to anyone. A lot of these things do, right? That clearly applies to anyone. If your assets and income sources aren't sufficient to sustain you, what are you going to do about it? What are you going to do to change that? And you really are, knowledge again is power, and you're at a point where you can make those choices and you can be realistic and make decisions along the way that will make you stronger in the long run financially. And if things aren't sufficient, how are you going to adjust your budget? Are you going to find a different job? How are you going to save more so the money is there at the end of the day when you want to retire? And, you know, one of the big things is real estate market is crazy right now. We all know that all over the country. You need to be realistic about how much you want to tie up on a home, how much of a mortgage you want to commit to. Again, in this kind of new state, looking forward to putting your new life together post-divorce and how that should be. So working with someone to have a really good financial plan is what you need to do. And now I think we're going to turn to Q&A, and I think Susan is going to help us with that.
Yes, I'll be handling that. And we have a bunch of questions that have come in, so let's get started with that. First question is, if you have assets that were acquired prior to a second marriage, are those assets at risk in a divorce? I guess, Nicole, that one sounds like for you.
Yes, so they are to a certain extent. So if you're able to keep assets completely separate, not commingled at all, they are likely going to be fine in the event of a second divorce. However, if you start tapping into those assets to help pay the mortgage, for example, or use money from a premarital asset to buy, let's say, a vacation home, that money is now going to become marital and not going to go back. So without a prenuptial agreement, it's not as tight and it's not as black and white and gets a little gray.
Okay. Another question is,
do you have any... vary by state law too. I'm sorry, Susan. And that can vary greatly by state law.
Right. No, that makes sense. Are there any best practices for a client who's contemplating a divorce and might be getting a significant gift from a parent before the divorce gets finalized?
Well, so in New Jersey, for example, inheritance is exempt from equitable distribution. So even if you're getting an inheritance in the middle of the divorce, 5 days before a divorce, or 5 years before a divorce, again, if it's kept separate and not used, it's still going to be your property in New Jersey. But again, most people have to use their assets in one way or the other. So if they're used for a marital purpose, you're not getting that money back at the end of the day.
All right. I think, Elizabeth, this one might be for you. Does the default rule that you mentioned apply to life insurance?
That depends on state law. I know that in New Jersey, it does not apply. Anything that has a beneficiary designation, you have to change the designation on that account. I thought we had one of the slides had a list of for New Jersey, I had put the this is slide 29 if we want to go back to it real fast. I don't know where it is. Well, maybe it doesn't matter. But point is, the statute really does not change a lot of things. You're really left to your own devices, so to speak, to make sure that the documents, or I'm sorry, the accounts are up to date as to what you want them to be after the divorce. So for New Jersey, it's disposition under a will, which would not cover life insurance, nomination as a fiduciary, and a jointly owned asset. Again, that's not life insurance.
In the disclosure process during a divorce, do you need to disclose assets in which you have a discretionary interest?
You would have to disclose them to the extent that you're actually getting money. If it's something that can be revoked at any time, or it's conditioned upon something that hasn't happened, you would still disclose it, but then you would put a qualifier in there of, my parents control this trust. I'm never getting access to it until X, Y, and Z happens, or X, Y, and Z have to happen in order for this to happen, or I can't touch this money at all until I'm 45 and I'm only 32.
What should someone...
And just, Susan, can I add something there? That's one of the really powerful tools of using trusts and planning, is that parents can put these types of restrictions on the assets to really help their children. Now, there are some state public policies, you can't say my child cannot touch this asset if he marries, someone from another religion. Those things are not allowed, but the general, no access until age 35, or income only until age 35, and then access to principal, things like that can make a big difference.
All right, I think we have time for one more question, and then There are some other questions, so we will be sending all the questions to the speakers, and they could answer those questions offline in their discretion. So here's the last question. What should someone immediately do with their cash savings accounts and credit cards upon filing for divorce?
Well, in terms of anything that is there, if you start liquidating or moving money around, unless you're literally like sending money to your mattress, it's going to be found. So I always tell clients not to do anything fast, not to do anything furious, because it's going to get caught. Ultimately, the money is there and the money is going to be dealt with. But as Jody has said, as I've said, as Elizabeth has said, knowledge is power. You need to know where your money is and what it's being spent on to almost try to cultivate, what your financial picture is going to be.
All right, well, it looks like we're out of time. So I'd like to thank our speakers for really an outstanding presentation, and also to thank Fiduciary Trust for sponsoring today's forum. We'd also like to invite you to check out our other virtual forums that will be taking place. There's one this afternoon at 2, and you could click on upcoming forums widget located on the bottom of your console. Once you leave the event, a short survey will pop up in your browser window. We'd appreciate it if you could share your feedback on this event, as it helps us to provide you with the content most interesting for you. And of course, the attorneys who want to get their CLE credit need to put the code word into the survey. On behalf of Trust and Estates and Wealth Management, have a great day.